Hello and welcome back to Main Justice. It is Tuesday morning, August 11th. I'm Andrew Weissman. I'm here with my co-host, Mary McCord, and a plus one.
Yes,
which
we have a
guest. A very rare plus one. This weekend, Mary and I immediately texted each other and we were reading something where we said, okay, this would be great to bring people. So with that as the teaser, Mary, who is our guest who we're going to start with, and then what else is on our agenda for this show?
Well, let's keep our listeners in suspense no longer. So a pretty amazing complaint was filed, I guess, on Friday against Todd Blanche by a former assistant United States attorney in the Southern District of Florida who was fired at least according to the complaint, and we're going to talk to his attorney, Margaret Donovan. That is our guest. According to the complaint, it was pretty blatantly based on speech, his own speech that he had, spoken through a legal blog years before he was ever a federal prosecutor.
Like a decade.
Yeah. So it came to the attention of the Department of Justice, at least it looks like by allegations in the complaint, through a defendant that he was prosecuting in a major Medicare fraud lawsuit. And so within literally hours of a social media influencer publishing about this, he was summarily fired. And we're going to hear directly about that from Margaret Donovan in just a few minutes. But that's not all, because that fits in to what, very nicely, I'd say, to what also happened this weekend, which was on Saturday by a vote of one vote margin, I guess I should say. Todd Blanche was confirmed as the Attorney General of the United States. And he, as we all know, has been not only by Pam Bondi's side when she was the AG when it came to retaliatory firings of AUSAs and others, but also has on his own, since Pam Bondi was fired, kind of, I would say, put that effort into overdrive, not just the retaliatory firings, but retaliatory prosecutions, right? With indictments of James Comey that we talked about last week and other indictments, some of which we will also talk about today. Speaking of which, the SPLC indictment.
Yeah, and one thing just to quickly interrupt is, when we did our show with Sunitha, that to me, that just fits in so well with the Todd Blanche story. And, one of the things I found so chilling in that episode, and I'm sort of raising this so that, people, if they want to go back, can listen to it, was her talking about when Todd Blanche came to her office and said, your obligation, whether you agree or disagree with the cases that we're assigning to you, you have to do them. And she was thinking, I just got fired for doing that.
Yeah.
For doing exactly what you said.
And of course, you're referring to Sunitha Dodamani, an Eastern District of Michigan prosecutor who was fired after based, at least it appears, on her role in prosecuting FACE Act cases, that is freedom of access to clinic entrances.
No other reason was given. Yeah,
that's right. Article 2 of the Constitution, just like with the AOSA in Florida. So we'll talk more about that. We will then talk in terms of retaliatory actions by this Attorney General, a little bit about the indictment of the SPLC. And the SPLC did move to have that indictment dismissed on the grounds that it was vindictively brought. A judge in the Middle District of Alabama rejected that argument in a written opinion that we will discuss, said that frankly, it was just too much speculation that this was based on vindictiveness and not other reasons. And we'll dive into that some. And then, of course, we will talk about the ballroom decision. Very, very long, pretty technical legal opinion by a 2-1 vote in the DC Circuit. But the upshot of it is that the ballroom construction above ground that does not have anything to do with the security underneath the ground is supposed to halt. But the DC Circuit gave the president and the administration 14 days to seek review in the Supreme Court, which everyone anticipates he will do. And then we will briefly talk about the two new executive orders that appear to be intended to try to continue to ratchet back birthright citizenship. But just like with the first effort, I think these will fail. So should we jump right in with Margaret?
Yeah. So Margaret, welcome to Maine Justice. And, your biography is so amazing. Rather than have Mary or me introduce you, I was wondering if you could tell the audience a little bit about who you are, what you're currently doing, but also your public service.
Yeah, sure. And thank you both for inviting me. And I will pretend that buildup is not entirely nerve-wracking to me. My career is actually just a sort of an ordinary person who's been assigned to extraordinary things. Right now, I'm involved in a lot of different cases against the administration. I've mostly been representing AUSAs who have been wrongfully terminated and FBI agents who have been wrongfully terminated. And I do that. That's pretty much 100% of my practice right now. I work at a law firm, Koskoff and Beater in Connecticut, who really values this type of litigation and understands the role that lawyers play in democracies when those democracies are under attack and those institutions are under attack. And so they've really quite graciously given me a lot of leeway to take on these cases. I spent pretty much my whole career in government. After I graduated law school, I went active duty in the Army. I was a lawyer for the Army and the JAG Corps. I did 2 combat deployments. I deployed to Iraq in 2016 and to Syria in 2017. I was with these sort of storied military units. I was in Iraq, I was with the 101st Airborne Division. And in Syria, I deployed with a Special Forces Group, 5th Special Forces Group. Then I left the Army in 2018 and I became a line prosecutor in Connecticut, in the District of Connecticut. I was in AUSA here in New Haven. I was hired under John Durham and worked for Vanessa Avery as the next U.S. attorney. And then I got out in 2024. And within 6 months after the inauguration, it was clear that there was a crisis. And as I said, my firm just basically graciously let me represent my friends and colleagues who were being targeted by the administration. And it really just boils down to constitutional law in many of these cases. And one benefit that we have, as you both all know, is that there are a lot of former DOJ people right now. And so the DOJ has basically fired their A-team, and the A-team is on the outside now.
Is now suing DOJ.
Is now suing DOJ. So that's also been something that we've been able to leverage. I also am a lecturer at Yale Law School, and I work at the Peter Gruber Rule of Law Clinic with some former DOJers, Bruce Swartz and Sonia Mittal and Harold Coe. And that clinic's been really amazing in terms of helping with the fight in this area.
It sure has. But you said constitutional issues. So that's, I think, a perfect segue to the complaint that was filed, because really we are talking about retaliation for the exercise of constitutional rights, not just freedom of speech, but also retaliation based on sort of perceived political affiliation. But before we kind of get into that legalese, for lack of a better word, can you just summarize for our listeners sort of what the facts are alleged in this complaint? And the AUSA at issue here is a man named Will Rosenzweig.
Yeah, that's exactly right. So I represent a former AUSA, Will Rosenzweig, who is not only was an excellent prosecutor, but is also just a lovely person. And we were connected about a year ago because last September, he was with his family observing Rosh Hashanah, and he wasn't checking his electronic devices on that day. And around 8 p.m., when he did check his phone, he realized he had been summarily fired. And Will's case is extraordinary, even among the extraordinary corruption that we've already seen. He was 2 weeks away from a multi-million-dollar, multi-defendant Medicare fraud trial in the Southern District of Florida. And he was fired, basically on the eve of trial. There was less than 2 weeks to go.
And he was the lead lawyer in that case, correct?
Yes, he was the lead prosecutor. He had indicted the case, a couple years, I think a year and a half prior. And he was, ready to go to trial. And it was going to be a 5-week trial. So this is a serious trial. At the time that he was fired, he had already filed the government's exhibits. They had over 40 witnesses and 400 government exhibits. So this is a really serious case that requires a lot of involvement from the prosecutors assigned.
And he'd already won, I think if I read your complaint correctly, the defense, as is typical, had tried to put the trial date off, but, the judge had denied it. And so this was something that your client, who was representing the lead lawyer, representing the United States, it was like saying, no, these people need to be held to account. He had successfully gotten a trial date that was going to happen. And we all know what it's like in that last few days before trial, when you are just, full bore.
Yeah, completely. And the tensions are as high as they can be. And to your point, the continuance is just an interesting detail that I appreciate that you both would have picked up on, because basically the Friday before Rosh Hashanah, the parties had a meeting with the judge. It was just kind of a standard pretrial meeting. And the defendants had cited a health concern of one of the defendants and were basically urgently seeking a continuance. And as we allege in the complaint, one of those counsel had called Will and said, it's a matter of life and death. Like, this is really important. We need a continuance. And Will actually agrees to it. He doesn't want the case severed because, of course, nobody wants to try the same case twice. But he does agree to the continuance. But the judge denies it. The judge says, no, we're going. And so the defendants don't get their continuance on that Friday. The weekend rolls around. Like I said, Will travels out of state to be with his family for the holiday, and then he gets fired on Tuesday. We have basically the PDF that he was emailed, which I'm sure you guys have discussed on the show before, Article 2 firings. It's basically a very perfunctory letter, one substantive paragraph talking about under Article 2 you're fired, and he gets that in his inbox at about a little around 6:30 that night.
And let me just jump in for a second, just to make sure everybody's tracking with us. When we're talking about Article 2, we're talking about this president who thinks that under Article 2 of the Constitution, as the head of the executive branch, he can pretty much do anything he wants with respect to the executive branch, including the Department of Justice and including firing at will pretty much anyone in the executive branch, even if Congress has imposed all kinds of restrictions on the firing of people like Will, who was a career employee, at most an inferior officer, really probably just an employee, and not political. In other words, not a political appointee. The president can fire at will a political appointee, but Congress has seen fit to make a distinction between political appointees and career DOJ and other career government employees and establish protections for them. So this idea of an Article 2 firing was basically under Article 2 of the Constitution, you're being fired. That's a brand new animal. That did not exist before this administration. And that is partly why we're seeing so much litigation.
Yeah. No, but I appreciate that on the Article 2 thing. And basically the president is, when people are getting these letters, and Will's case stands out for a number of reasons that I'll talk about, but when people are getting these letters, it's basically the president trying to convert line prosecutors to being political appointees, which anybody who understands how criminal cases work, that's totally insane, because criminal cases don't wrap up after 4 years and you can just switch out prosecutors. And of course, it's not what Congress intended. So Will realizes that he is fired about 3 hours after an right-wing online influencer had posted about him. And she posted basically he had almost 10 years prior, in 2016 to 2019, he was a private citizen working at a private law firm, and he had published an online blog, and he had done an op-ed in The Hill. And in his publication of this blog, he published criticisms of candidate Trump at the time, because 2016 was still during the campaign. And when President Trump became president during the first term, he published criticisms of him as a president then. And this was actually not really the main focus of the blog. The online influencer basically announced that Will ran an anti-Trump blog. There's no question that some of his posts were definitely criticizing Trump. That's definitely true. And even if it was a full anti-Trump blog, we would still be in the same position here.
Exactly.
But I just think it's also interesting that this was actually quite cherry-picked, what she selected to sort of present him as optically. And, the blog talked about all kinds of things. It talked, March Madness and baseball. And I don't think you have to have gone to law school to understand that a private citizen criticizing his or her government, that's like
core
central.
Protected political speech. Nothing more central to the First Amendment, really, than that.
Just to differentiate it, there are First Amendment protections if you are in the government and speaking, but they are less. because there's a concern that if you're in the government, are you saying something that would undermine your efficacy and sort of your position, et cetera. But you are not in that situation here. This is somebody who 10 years before, as a private citizen, and to be clear, there is nothing to suggest that there was any speech while he was a government employee that was criticizing, not criticizing in any way the president or any president. So this is core and deserving of the highest protection.
Yes, precisely. Not only was this not when he was a government employee, his last post was January 2019. He accepted a job with DOJ later that year. And because of the pandemic and other issues, he actually didn't even start at DOJ until September 2020. So we're talking almost 2 years after his last post. He starts at DOJ in the first Trump administration. Right. He gets a security clearance and a background check. So not only was it long before, but Andrew, to your point, we link to this in the complaint. DOJ's current policy is that you can have political blogs, just don't use government computers. And you can have political speech, but don't use government property to do so, and use common sense limits on that. And so we link to the DOJ's current policy, which basically says this is completely okay. But the difference with Will is that there's a online influencer with hundreds of thousands of followers who tagged then Attorney General Bondi, now Attorney General Todd Blanche, the SDFL's main account, and Ed Martin in her post.
And the letter that your client got, who did it come from? Who's the signatory?
The signatory is Pam Bondi in this letter. And it was created because they didn't erase the metadata on the PDF. We know that it was created less than 3 hours after the influencer's post.
So you've got somebody who's about to get a trial who with no notice is fired. So you've got this First Amendment issue. But just in terms of all three of us have served at the Department of Justice. You have also served in glittering ways as a JAG. We understand what it is to have the privilege of representing the government and how the care that requires. Could you just talk about what the surmise is that seems pretty detailed and forceful to me in your complaint about sort of how the influencer learned about this, and then where did it leave the criminal case as a result?
Yeah, I will give the obligatory caveat that we've alleged facts in our complaint, and I think the court and later through discovery, we can develop those further and people can draw their own inferences. But what we have alleged is that the influencer, not only did she post about Will's old blog post, but she posted that he was now prosecuting MAGA patriots. And so some of the initial facts, the peculiarities, I would say, of that post is that Will, while he was a very good prosecutor, he was not a national figure. He was basically a rank and file prosecutor in the Miami U.S. Attorney's Office. And this healthcare fraud case that he was about to start was an important case with serious charges. But something that I learned about the Miami office, there actually wasn't a press release, an automatic press release after the indictment. So it wasn't actually covered in the national and local media. So the idea that this online influencer would suddenly zero in on a random blind prosecutor in a random office in America and talk about his current prosecution. We don't know why she called them MAGA patriots, but talk about his current prosecution is totally bizarre. Then you have the added complexity of Will's co-counsel obviously had to take over. When the government came back a few days after Will was fired to try to seek a continuance, the defendants oppose it. And so a week before, they had urgently needed it, and it was a matter of life and death. And suddenly, when the lead prosecutor gets taken out, they're basically seeking a tactical advantage there. So all of that is very unusual. Also, we learned, and we don't know how long this had been going on, but we learned that one of the defendants that he was prosecuting was a follower of this influencer. And so all of those facts raise a lot of questions. But really, the most shocking to me, in my opinion, part of it is that I'll fast forward. Basically, the government had to add 2 prosecutors to replace Will to the case. They moved once, got denied, moved for reconsideration, for a continuance. The judge ultimately grants them, a few weeks continuance for evidence. The government pulls it together. They get convictions on 2 of the defendants, the third one severed. And the U.S. attorney in Florida, a guy named Jason Redding Quinones, holds an all-hands meeting after the trial in I think, to sort of congratulate the attorneys who came in and took Will's spat and like restabilized the case. And at this meeting, which we allege it was reported in a local blog, it's an all-hands meeting, and the U.S. attorney says openly that the defendants forced the government's hand in firing Will. And I just so appreciate you bringing me on the show to talk about this, because I just think, as a former rank and file myself, and I know how you both feel, this is like the ultimate betrayal. Mm-hmm. The idea that the defendants that you're prosecuting, that your own office wouldn't stand up for you. It's remarkable on its face, because even without all of this, it's remarkable that the government wouldn't recognize what is so flagrantly a First Amendment violation, were they to fire him, that they just forgot about the the fact that he was a private citizen. They didn't bother looking into whatever the allegations were. But it's even more remarkable to me, and I think most offensive to me and to other people who learn about this, that you could be a line prosecutor and your U.S. attorney, instead of telling, if the facts play out, that the defendants did refer this to the government and they went to the U.S. attorney, maybe we allege that Jason Redding Quinones had a conversation with Todd Blanche. If the facts do bear out that the defendants were to do this, the idea that the U.S. attorney wouldn't immediately just say, get lost at best, or more extreme and probably more appropriate, seek an obstruction of justice, at least a sentencing enhancement, or if not, opening an entirely new criminal investigation, trying to figure out, why are you trying to take out a prosecutor? Why are you going after my prosecutors? But that didn't happen. If this is how the facts actually occurred, which discovery will show us, it sounds like the U.S. attorney just folded and was like, yeah, okay, you can take out my prosecutor.
And folded at the potential expense of, not being able to go forward in a significant $17 million Medicare fraud case based solely on some influencer on social media saying that this AUSA, right, was anti-Trump. I mean, that's what it boils down to. It's completely nuts.
Yes.
Yeah, so it's ass backwards. Yeah.
But I will also point out one other thing. This is, just to put this, map this out, this is the same United States attorney that is now sort of in charge of, or at least the investigation is coming out of his office into this supposed vast conspiracy to deprive Donald Trump of his civil rights, starting back with the Russia investigation when I was still in the government, when Andrew then was part of the Mueller investigative team, up through 2020, through Jack Smith's investigation after January 6th, et cetera, et cetera. And so it's not too shocking to me that United States attorney would have done nothing in the face of the facts as they've been presented here, Margaret, because if this is somebody who is willing to engage in that type of ridiculous conspiracy theory, conspiracy investigation, then this fits very like a glove with that.
I know it's the same with both of you, but my heart just goes out to the line agents and the rank and file prosecutors that are still out there right now, that are just trying to hang on to their health insurance and their jobs. And oh, by the way, their public service.
That's right.
Every American citizen who wants to serve their government should be allowed to do that. And they shouldn't have to silence themselves and spend their entire adult life not criticizing their leaders because they're worried they won't be able to serve in government later on. That's insane, and it's unconstitutional. And so my heart just goes out to them, because now, on top of it, they have to be worried that your U.S. attorney, who should be backing you up, who should be telling defense counsel to get lost, like get out of here with this nonsense,
right,
is actually just turning you in and throwing you to the wolves and throwing you to the online mob for the very defendants of the case that your office assigned you to prosecute. Like it's just completely backwards. And it is, like I said, it's such a betrayal. And it's, to me, those types of people cannot be leading U.S. attorneys' offices. And to your point, Mary, yes, this is the U.S. attorney's office who, we're supposed to trust has the credibility to prosecute this so-called grand conspiracy case.
Right.
Margaret, we just have a little bit of time left in this segment. Could you talk to us just a little bit about what's next? What are the sort of legal issues coming up? Where does this case go from here?
In a normal world, AUSAs don't bring employment actions in district court, and we certainly recognize that. But as you pointed out in the beginning, these Article 2 firings are a new invention of this Department of Justice. This way that Article 2 has been cited as a supposed authority that can exist outside of the Civil Service Reform Act, exists outside of apparently the Bill of Rights, and can supersede both of those bodies of law. That is a brand new invention of this DOJ. And so in a normal world where a typical employment dispute, let's say somebody's performance is bad or it was otherwise a for-cause firing, that gets channeled to an executive branch quasi-independent agency called the Merit System Protection Board. For various reasons that are too long and boring to go on here, the Merit System Protection Board has basically been disabled by the Trump administration because of their stance against independent agencies within the executive branch.
Supported by the Supreme Court's opinion in Slaughter, which we discussed a few weeks ago. Yes, which basically says for independent agencies or quote unquote independent agencies, the president can just fire at will, with the exception of the Federal Reserve Board.
Yes, with that clear exception that is so different than every other independent agency. So you have sort of this disabling of the independence of this agency. In fact, the MSPB on its own website no longer calls itself independent, which of course is completely contrary to congressional purpose when it was set up. And then you have, again, the other layer of the fact that these Article 2 firings are a brand new invention and were not envisioned as the type of termination that gets adjudicated within that body. So jurisdictionally at the outset, I'm anticipating we would have a challenge there. We've had that, as you both know, AUSAs have filed. There's been a few AUSA cases in other districts, and those cases have so far, chiefly Maureen Comey's and SDNY, has established that in fact, AUSAs who are fired under Article 2 can, in fact, have that litigated in an Article 3 court. And we anticipate facing that challenge in the Southern District of Florida. We have seen victories so far in the Eastern District of Virginia for Article 2 firings and the Southern District of New York. And like I said, we have every intention of bringing that fight to the Southern District of Florida and seeing how the bench evaluates the issues there. And assuming that we prevail on the jurisdictional argument, we would then move on to the merits. But I do want to point out there's actually one sort of, just for the law nerds who listen to your podcast, there's one sort of fun part about Will's case that is different than the other cases, although I may, we may apply it in other cases. I have wonderful co-counsel on this case, from Fredman Fells and Soto. And one of my local counsel actually experienced this firsthand when he was in DOJ. They basically pointed out that the Privacy Act actually forbids the DOJ to collect First Amendment protected activity of its employees and then fire them based on it. And so we have a Privacy Act count which entitles the plaintiff to monetary damages. And it also, again, exists outside of the MSPB.
I noticed that because I hadn't seen that before. So you've got your First Amendment claims, your separation of powers claims, your Administrative Procedure Act claims, and the Privacy Act. And we will be following very, very closely what happens in this case, Margaret. Thank you so much for joining us.
It's such a privilege to have you on. It is horrendous what the allegations are here that frankly seem, beyond dispute, at least on the face of the complaint. It is also a wonderful story, though, for people to know that there are people out there like you doing this work, because there's so many stories about law firms caving and the sort of complicity that's going on, particularly in big law. And so it is great for people to see that AUSAs who are wrongfully fired are, pushing back and want to have their rights vindicated, but that there are people like you out there as a resource and dedicating their time and lives to it. And so thank you very much for coming on to talk to us about it.
Well, thanks for inviting me, and I'm grateful for your podcast for discussing these issues for the public.
Thanks so much, Margaret. So let's take a break then and come back, and we will talk a little bit more about Blanche's confirmation and some of the other retaliatory things that we expect from him as he continues as the Attorney General. Well, welcome back. As promised, that was a great discussion, Andrew. I'm so glad that we had Margaret on. And I think, we have focused on a few of these firings. We had the episode where we had Sunita Dodamani on a few months ago. And it's just a big, big deal for those of us who are main justice veterans, right? To see what has happened to the department. So many people fired, beginning, on day one, right? With the firing of Jack Smith's team, right? It's been going on and it continues to go on. And it's important that some of these people at, great risk, really, it's really sticking your neck out to file a case like this, but people are doing it and to bring attention to it. And also because it's just what happened is wrong.
Yeah, absolutely. And, it's turning to the issue that Todd Blanche is now the Attorney General. One of the things that just did not get traction and should have in the Senate, among many, many, many other issues, is these firings, and that Todd Blanche boasted about them and was like, look what I did for you, sir. And so to me, the hollowing out of the department, and I'm including now the FBI in that, because you remember the FBI is a part of the Department of Justice, and that you have lost hundreds and hundreds of years of expertise. And, I heard Brian Driscoll say this, which is, you know how long it takes to get 20 years of expertise?
20 years.
20 years. There's no short circuit for that.
Yeah.
And so this is something with devastating consequences. There's so many other things that he could be criticized for, but one of them that happened this week is various lawsuits that we have talked about in the past that have been brought. And the one that is pending against the Southern Poverty Law Center, the SPLC, did have a decision this week. The claim by the Southern Poverty Law Center was that there was vindictive prosecution. That is, that the case was brought by the prosecutors and agents to retaliate against the SPLC for its opposing Donald Trump, and essentially for it's a very much like its First Amendment speech. So you can sort of relate it,
and it's hate map, right? This hate map where they kind of literally do a map, mapping out different groups that they, according to their criteria, are involved in hate speech, hateful incidents, encouraging hate. And that is something, that is really anathema to this administration, because some of the groups that were called out by SPLC on this hate map, again, as an exercise of their own First Amendment rights, are groups that are very, very pro-President Trump and pro his administration.
So I had a question. So there was a decision from the district judge, and she said that the standard, both for seeking discovery, which is a slightly lower standard, and then the standard on the merits of whether there's vindictive prosecution. She said neither of those standards has been met by the SPLC. And so she denied the motion, saying that it just simply has not been shown. And I read this very carefully, and I'm going to be really interested, Mary, in terms of what you thought she may have gotten right, what you thought she may have gotten wrong.
Yeah. So, this is a much more difficult argument for SPLC to make than, for example, the argument that James Comey has made in his vindictiveness motion, his motion to dismiss the Seychelles prosecution on vindictiveness grounds. And we talked at length about that last week. Just to tell the story of even the timing of things there almost proves the vindictiveness. I think one of the things that made this tough, and this is something that the judge focused on, and I think there's parts of this she's right about, is that timing here alone doesn't paint quite the same picture. She wasn't contrasting it with Comey, but I am. Doesn't paint a sort of definitive picture of actual animus. And that's because there was an investigation opened by the IRS into the SPLC's use of paying informants back in 2019, so that would have been during Trump 1, that was continued into the Biden administration. At some point, it was then closed without any, prosecution in the Biden administration. And then it was reopened in now Trump 2 and an indictment brought. And you can say, well, does that look vindictive? Well, it could be, but it could also be, as you and I know, sometimes prosecutors reevaluate cases at different points in time. And it could also be, at least she says, just a reevaluation of, a case that I guess under the Biden administration, they decided not to move forward with. And in her view, what SPLC was trying to argue beyond that was just too speculative. It couldn't meet the burden of proving actual animus or getting a presumption of animus based on something like the timing. And I do think this is a tougher case than the Comey case, but the SPLC had put together some other arguments, including pointing to that hate map, pointing to the criticisms of that hate map by people like Stephen Miller and people who felt like these were their friends, and in some cases their own organizations on that hate map, really pushing for punishment based on that hate map. And some of this happened after Charlie Kirk was murdered. And so they tried, they did what they could with their facts. And the judge, I don't think it was crazy for her to say the connection is not strong enough. I did think, though, there was enough there for discovery. That's the part that really disappointed me because, maybe we're not enough for a presumption. I think reasonable minds could differ. Maybe it's not enough to show actual animus, because another thing the judge does is she looks at statements by members of Congress, statements by Donald Trump about SPLC, but there's, you can't tie members of Congress to what the U.S. attorney in Alabama did. I think she didn't give enough credence to the fact that the U.S. attorney in the Middle District, Alabama, would have felt pressure from Todd Blanche and Donald Trump to bring this indictment. She seemed to think there was inadequate proof that U.S. attorney himself had that animus. And I think there's enough there to show, well, he was being pressured, just like in the Abrego Garcia case, right? Todd Blanche figured prominently there because of his pressure on the actual U.S. attorney in that district. So I don't think she gave enough there. But even if it wasn't enough right now to dismiss, what surprised me the most is the denial of discovery on the issue.
So it will not surprise you that I come out where you do, in that I don't think that you can look at this decision and say that it's crazy and off the wall or in bad faith. It is a tougher case than Abrego Garcia, than Comey, than so many other cases. That being said, the reason I agree with you that at least for discovery, which is this lower standard, can you at least get discovery? And let me just give you an example, by the way, of the judge being fair. The government took the position that vindictive prosecutions can only be based on sort of a violation of sort of procedural rights,
right,
but not substantive rights, meaning you can directly violate someone's First Amendment, and the government was taking the position that can't apply at all. And she rejects that soundly.
That's right.
And says, no way. That's not the law, and I'm not going there. So then this is not a knee-jerk, I am protecting the government no matter what you say. But here's where I think to me, I thought this was a tell, was footnote 12. And footnote 12, I know, by the way, our audience is probably like, isn't this exactly why we listen to Main Justices? Because
I have it highlighted.
So footnote 12 is, we have covered in the past that Todd Blanche famously said something on air about this case on Fox News that was flat out wrong and got called out with filings by the SPLC saying this needs to be corrected, it's wrong. They wanted various relief. And only then did Todd Blanche correct himself, but he corrected himself in a way that was fundamentally at odds with the theory of the case. And in footnote 12, the judge basically just says, oh, this was a slip of the tongue, and he corrected himself. That, I did not think that was giving a fair reading of what happened. And I think in deciding whether something is vindictive, you can consider the complete weakness of the case and the theory of the case being at odds on the face of the indictment. In other words, if it's so weak, you ask yourself, why would you bring it?
Yeah.
Because you wouldn't win at trial. At least for certain of the counts here, I think that's really true. Maybe the bank fraud's less true, but for the sort of core of the case.
The defrauding donors really is what the part we're talking about. Yeah,
exactly. And that is so what Todd Blanche had to correct himself to say was at odds with the idea of defrauding donors. But the fact that she just said, oh, this is a slip of the tongue, and then didn't get into how weak that is in light of his statements and in light of actually some of the allegations in the indictment, I thought that was a gap in, if I was like, if this was appealed and I was on the appellate court, that would be something I would be like, I'm sending it back to you because you have not considered this. And that to me throws it over into, you didn't meet your burden to, yes, you met your burden for discovery.
Yeah. Yeah. No, I that's the part I think is the most wrong, is that, it doesn't take a high level of evidence to get discovery. I think they have enough there in this case, particularly given so many other things going on. And one of the things this judge does that's different than so many other judges is she actually says, essentially, the government is entitled to a presumption of regularity unless you can show me that in this case, they are not. And she just doesn't find it here. She doesn't go into any of those others. She's just like, you haven't shown me here, because prosecutorial decisions are really, really given a whole lot of respect. There's a huge amount of discretion when it comes to a prosecutor making a decision to prosecute. And I'm not going to peek behind that here. So this is a blow, obviously, to SPLC in this case. That means it's not going to be dismissed on these grounds. They have certainly other arguments they're going to make, not only, pre-trial, but also in the course of moving forward toward a trial. And of course, substantive defenses, to get to your point on the strength of the charges, substantive defenses to all of the counts. But I would have liked to have seen a little bit more inquiry here into allowance for them to get a little bit more inquiry into exactly how this indictment came about.
And just so people understand, I mean, there is something to the law in terms of like, we're not going to allow discovery on a certain issue unless a certain burden has been met. But let's assume that there really was bad conduct here, and that the Deputy Attorney General or Attorney General's office was orchestrating this CEG, what we learned from the Abrego Garcia discovery. And this blocks all of that.
Right.
So we never, ever see it. And so it does fall into sort of a catch-22, which is, hey, in order to show vindictive prosecution, you have to be able to show me that there was vindictive prosecution, and then I'll give you discovery into vindictive prosecution.
Right.
I mean, I'm overstating that, but it's like, but that's sort of the issue here, is that if you are not myopic and you put this in the context of everything that we are seeing emanating out of Main Justice, why should this be different? what we're seeing such orchestration. I mean, our last guest just talked about that, right? And that's just one example of things coming from Main Justice, and presumably, it could be Main Justice and higher. I'm talking to you, White House. The idea that you're going to keep this with blinders on is a little fanciful. So, Mary, should we take a break? Because I actually think the idea of presumption of regularity fits in so well with some of what came up in the ballroom case. And
it does.
I'm pretty sure, yes, this is one where I know you and I highlighted the same part. But why don't you take a break and we'll come back and talk about the ballroom case.
Sounds good. Welcome back. As promised, the ballroom decision. So on Friday, the DC Circuit issued a 2-1 ruling, basically halting, again, the continued progress toward the building of the ballroom, at least the above ground parts of the ballroom, with an exception for things that needed to be done for the safety and security of the president and the occupants of the White House, because the ballroom, the new ballroom, is being built just right, adjoining to and next door to the White House, which is where the old East Wing used to be before it got bulldozed without any authority. So let me start really quick with sort of like technically what this opinion does, but then let's move on to what I think a lot of people might find more interesting, which was the sort of lack of presumption of regularity, or lack of regularity, I should say. Technically, this is a very, very long majority opinion, 100 pages, and then about another 35 pages of dissent. And it is basically saying, look, the Constitution gives Congress the control over federal property under the Property Clause and the funding of the maintenance and development of federal property. It doesn't give that to the president. The White House is not the president's personal residence, right? It is federal property. There was no express or implied authorization by Congress for not only the destruction of the East Wing, but also not for the construction of a new ballroom, by the way, which by its design would literally dwarf the White House and the West Wing because it is gigantic. And that there are express statutory limitations that Congress placed on construction of things like a ballroom or any other facility or building on federal property, which were violated here. So their substance of the ruling is very much, this violates the Constitution and it violates statutes. There's a lot of other detours along the way, lots of different statutes that apply, a long detour into standing, because this is brought by the National Historic Trust.
The National Trust for Historic Preservation in the United States.
There we go. Okay, that's the plaintiff, and they were able to show that one of their members, a professor who has done all kinds of work when it comes to historic preservation, is somebody who they said would have standing, and that's enough for the association to have standing on behalf of its members. Long detour into that, but the upshot is, this violates the Constitution. You should have gone to Congress and sought authorization. You didn't do that. Go back and do it over.
And in many ways, it's a similar issue, very different statutes to the Tariff Supreme Court decision.
That's right.
This is saying the Constitution gives the power to, with respect to taxing, to Congress, not to the executive branch. Here it is beyond peradventure that we're talking about something that the Constitution gives to Congress. And so the issue is, did Congress somehow delegate this in a statute to the executive branch? So is there some statutory delegation? And the answer is no. There's so many aspects of this that are interesting and telling. I wanted to maybe start, Mary, with some of the language, because just like in our show notes, we'll link to the Rosenzweig complaint that we first started with. We'll link to this decision as well, because the first few pages of it are beautifully written. And here's an example. It starts this way. The White House is the people's house, and under the Constitution's property clause, Congress exercises plenary control, that means full control, over the building and its surrounding land. Each president is a temporary tenant, not the owner of the White House and its executive residence. The president has no and claims no constitutionally assigned authority over that property, which is designed and maintained for the use of all presidents, current and future, and for the American people. We are aware of no instance in American history in which a president unilaterally and using privately collected funds demolished substantial portions of the White House that Congress authorized to be built and American taxpayers paid for until now. So that gives you some sense of the flavor. It is very much written for all of us, lawyer or non-lawyer, to be able to read, to understand what's going on. In spite of it, as Mary said, there are a lot of technical aspects. Here's a quick thing about sort of presumption of regularity. It is pointed out, I think, quite sharply that the government, the court doesn't say it this way, but I will say lied to the district judge. And this is what I mean. When it served their interest, the government took the position in writing and in its oral presentation to the district judge to say that the two parts of the construction, the underground part and the above ground part, were totally separate, and they could be legally interpreted and evaluated separately.
We should say why they did that then, because they wanted to say and did say to the district judge, Judge Leon, we can keep working on what is underground and it won't impact what is above ground. So judge, when you're thinking about injunction, don't enjoin us from continuing the work underground to build a bunker and all kinds of national security related stuff that they should have probably never said publicly, because now the entire whole world knows there's going to be a bunker under the ballroom, probably the least safe place ever. But at any rate, what they said is, you don't need to enjoin that because the bottom doesn't have anything to do with the top. That's why it was in their interest. And then what happened?
So then the judge says, okay, fine, I'm going to separate the two and I'm going to let you, for security purposes, do that. And so then the government turns around and says, oh, no. They're one. This is entirely one unit. And so if we can go forward with the bottom, we should be able to go forward with the top.
That's right.
Directly contrary what they had stated to the court. And so, the legal doctrine is you have forfeited the argument. Once you have said the opposite, the court relied on it, you're done. You don't get to turn around unless you can explain something that suddenly changed, but they didn't. So that was a remarkable point to this. And the reason I think people should understand why Mary and I are honed right in on this is this is the Department of Justice. This is the kind of thing that if you were just thinking about what the meeting is like beforehand, about what you're going to say in court and how you're going to approach this, if you're just not going to be like, oh, let's just say the opposite now to the court. It's like that does not happen. And it bespeaks how many judges are balking at this. It's because of this sort of cavalier attitude of say whatever the hell you need to say at the moment to prevail, regardless of whether you said the exact opposite. I would just be so ashamed as a lawyer, but also I really do think there have to be consequences for this. This is the kind of thing that any of us would be thinking beforehand, you're going to lose your bar ticket. But there really has become part of a norm that you think you can get away with this.
Yeah. One of the things, like you said, that the majority here really homed in on, and to the point that you were just making, they really expressed some outrage over the government's not just change in position, but the extent to which the government's argument would go if you theoretically took it to its end, because they asked the government at oral argument. The government argued that despite whether they've got authority or not, that when it's a matter of national security, you've got to just defer to, the government on this. And the court goes through some of the oral argument transcripts and says, when asked, when it became impossible for courts to stop this project, the defendant stated point blank, it would have been improper to enjoin it even on day one. Question. And so your position is that this can't be stopped by a court, that the district court, this court, the Supreme Court, no court could stop the building of this today? Answer, yes. Question. Imagine that you are wrong on the law. Imagine the statutes were as clear as could be and that you have no authority to do this and you've done it. There's nothing to be done. Answer. That is our position.
So does everyone follow that? We can act lawlessly. And as long as we have taken fast unilateral action,
court doesn't have any jurisdiction.
The one thing you have to say is kudos for
chutzpah.
Here it's chutzpah, which is we don't believe in checks and balances. This is falls into I kid you not. The at oral argument, the question was, but what if it's illegal? And the answer was you can't do anything about it.
Can you imagine saying that when you were you at DOJ? Sorry, court, you can't do anything. Bye.
Not only could I not imagine saying it, it would never enter into my brain. And this isn't one where you need to learn this in law school. You learn this in elementary school, right? When you're taught about, what is a law? What is the Constitution? I can still think back to, elementary school.
You sound so quaint, so rule of law based. Don't you know we're post rule of law?
So speaking of that, Mary, talk to us just briefly, because we're going to cover this in much more detail as these get challenged. But people have been reading that there are 2 executive orders that seem to be saying that the president is still trying to take away birthright citizenship, but for, it seems like, narrower categories. But didn't this get decided by the Supreme Court? And so what seems to be sort of a clear problem, isn't this just sort of they're just doing what the court said you can't do?
Yes. In a word, yes. So there are two executive orders.
Okay,
one, I don't think we need to talk about. It's about not giving visas to people who are coming for birth tourism. The other one is called Continuing to Protect the Meaning and Value of American Citizenship. And it basically says federal agencies, you can't issue or accept documents that recognize citizenship for certain U.S.-born children where neither parent is a citizen. And note right there a difference from even the first executive order that purported to take away birthright citizenship for some people. It did still provide citizenship for children of lawful permanent residents. And this actually, that isn't even in there. It's like certain U.S.-born children where neither parent is a citizen. And then what it does is it purports to use language from Chief Justice Roberts' majority opinion that said this: any child who was born under the protection of the United States, that is, any child for whom no extraterritorial fiction applied, was made a citizen. That is Chief Justice Roberts talking about the 14th Amendment. What they do is they took this language, for whom no extraterritorial fiction applies, and decided to try to expand it. And what that extraterritorial fiction is that there were certain exceptions to birthright citizenship that gave you citizenship by being born on U.S. soil. And those exceptions were basically for foreign diplomats who have official immunity from prosecution, civil penalties, et cetera, under our laws. So the fiction is that, yes, you're here, but really, you're still extraterritorial because you're a diplomat with that kind of authority. They said...
So narrow exception.
Or alien occupying enemies, right? So like an occupying force here in the United States, you're here on the soil, but you are, still fictionally extraterritorial, narrow.
Right.
But they try to blow that up. Even if you don't have immunity, they're saying employees of foreign governments, you have children here. So like say an embassy employee, you might live here for 30 years. You have children here. You don't have diplomatic immunity. You're not the diplomat. You have some other role. Their children don't get it. They say people who are alien enemies with no real definition other than it could include members of foreign terrorist organizations or specially designated global terrorists. There are not low lists of foreign terrorist organization members, you don't get citizenship. So it's blowing this up. It's unclear how it's going to apply. It's vague in many, many, many respects, unclear what people are even supposed to do. And so the government is supposedly issuing guidance in 30 days. I suspect we'll see potential challenges before that and certainly after that, and we will cover those.
Absolutely. So, this is basically, not taking no for an answer. It's not like the court had left an exception and said, you can go forward, but in a narrow way. This is like, you cannot do it. To me, this flies in the face of the entire reasoning of the court. But just to put a fine point on it before we end, remember on the constitutional issue in that case, it was a 5-4 decision. So It is a very, very close case. But we will continue covering that. Mary, great to talk to you as always. Thank you so much for listening. Please remember you can subscribe to MS Now Premium on Apple Podcasts, and you can get this show and other MS Now originals ad-free. Plus, you can get subscriber-only bonus content. And as you all know, we're available on YouTube. Head to ms.now/mainjustice to listen there.
This podcast is produced by Vicky Vergolina. Our associate producers are Nicholas Vinuela-Yodar and Iggy Manda. Our audio engineers for this episode are Bob Mallory and Mark Yoshizumi. Katie Lau is the senior manager of audio production, and Aisha Turner is the executive producer for MS Now Audio.
Search for Main Justice wherever you get your podcasts and follow the series.